Miss Mather.
Lords, my lady, I appear in this matter on behalf of the appellant. My learned friend Mr. Robbins, King's Counsel, appears for the respondent. By way of roadmap to my submissions, they're organised into 5 topics. First of all, the character of the issue that arises in this case. That is to say, the relationship between unfair prejudice relief and derivative actions in a particular type of claim, where remedies that could alternatively have been sought in a derivative claim are sought alongside remedies that can only be sought in an unfair prejudice petition, in the context here of a corporate divorce situation. My second topic is then how an overview, the law and the relationship between unfair prejudice petitions and derivative actions, and in particular the breadth of what is permissible under Section 996 of the 2006 Act, applies to claims of that kind. In short, it is anything but exceptional to be permitted to pursue the entirety of the relief in the context of the petition. It is inherently likely that the corporate relief, the relief that could alternatively have been sought in a derivative claim, will be within the conceptual bounds of what can also properly be sought in the petition. And it's inherently likely to be convenient and appropriate to seek the relief in the petition rather than create a multiplicity of proceedings. So that's my second topic. Thirdly, I will then seek to make good those overview submissions by more detailed reference to the authorities. Fourthly, I will address the learned friend's submission that the 2006 Act has altered the position established by those authorities. I say it plainly has not. And fifthly, and finally, I return to how those principles apply to the specific contents of the petition in this case, and how, therefore, I say that the first instance judge erred in his analysis. I turn then first to the character of the issue in this case. It's a case raising, of course, a question as to the relationship between derivative actions and Section 994 claims, but rather more specifically than that, where the petitioner seeks both relief that could alternatively be pursued by a derivative claim and relief that could only be obtained in a petition. Could I ask the court quickly to turn up the petition, just to have firmly in mind what is sought and on what basis? It's in the core appeal bundle, tab 6. And to boil the petition down to its essential elements, one can skip to paragraph 11. There's the plea of the formation of a corporate form of joint venture and the plea of a joint venture agreement and the allegation of a quasi-partnership company immediately after that, paragraph 14. Then at paragraph 15, the pleading of Companies Act duties owed by the first respondent to the joint venture company. Then, beginning at paragraph 16, a plea of the relationship between the joint venturers breaking down, allegations of exclusion from management, and failures to provide information about the business to the petitioner. And then, beginning at paragraph 23, and especially at paragraphs 26 to 28, allegations that the first respondent used his practical control over the management of the company to misappropriate or divert its business and other assets in breach of his Companies Act duties. And specifically that he misappropriated those assets to offshore entities that he set up and controlled. And then at paragraphs 29 to 30, in relation to those entities, a plea of recipient or accessory liability against them, the proposed third and fourth respondents. And then importantly, at paragraph 32, the prayer for relief. And the prayer is intended to be read cumulatively and I submit should be read in that way, to seek a composite form of remedy whereby the assets are restored to the company, and alongside that, the first respondent is required to sell his shares to the petitioner. Just pausing there, that's perhaps not the commonplace form of relief on a petition, but it is, at least in principle, an appropriate and available one. In that regard, could I ask the courts?
Just to be clear, when you say that isn't commonplace, which bit do you say isn't commonplace? The combination or the buy-in order, or which?
Well, the latter, my lord. Where there is the latter, it then, in my submission, does become, well, I don't know if commonplace is the word, but certainly logical also to seek to restore the assets. And in a sense, that was where I was seeking to go next.
Sorry, can I just pause? Because,
Yeah.
sorry, I think I may have misunderstood the way your prayer works. Usually when you go for a buyout order, or at least, sorry, if the minority shareholder is seeking to be bought out, what they normally say is, I would notionally want the misappropriated value added back to the company for the purpose of valuing my shares.
Yes.
So it's a notional basis. Now, here you're seeking an order that it's a 50-50 company, but you're seeking an order that you buy in. Now, when it said at a valuation reflecting the losses, I assumed that that meant at an enhanced value. Sorry, that you buy in so you'd be buying the shares, but at a value reflecting what it would have been if the assets had been in the company. But you're saying no. The words reflecting the losses mean that the losses lie where they fall. I mean, the judge the judge dealt with this point.
He was concerned about an attempt to have one's cake and eat it.
Correct.
And I accept that that's a valid concern, but we couldn't do that. And I was going to refer to your lordship's judgment at first instance in Taylor Goodchild, where this issue is addressed in terms of the logic of the position. I accept that the pleading is capable of being read in the way your lordship's described. It's not the way it's intended, because there may be other respects in which it's appropriate, even taking account of restoration of assets, that it's appropriate to reflect losses caused. For example, if those assets consisting in the business have additionally lost value because of the conduct of the respondent in the meantime. Those are all matters of detail for trial in my submission and for the discretion of the trial judge at the end of the trial. But logically, I fully accept that it wouldn't be open to the petitioner to have his cake and eat it.
Yeah, in other words, to buy the respondent out at a price which was lower because of the fact that the company didn't own the assets.
Exactly.
But then cause the company to pursue a claim, it wouldn't be a derivative claim in those circumstances, having got control of the whole, then to pursue the respondent for the full amount of recompense to the company.
Well, that, but also...
I mean, that was exactly what was going on in Taylor Goodchild, I think, if my memory serves.
Yes, but my lord, also, if both aspects, as it were being dealt with at the same time, clearly there would be a windfall if all those assets were restored, and then that was also not properly reflected in the
amount that you have to pay for the
valuation. Yes.
Yeah.
And the petition is clear that what's being asked for paragraph 32.1 is for an order that the first respondent do sell his shares at valuation. It's not a petition that they simply be handed over.
So you're basically saying, if I have to pay the petitioner, if I have to pay the respondent a higher price for his shares, on the footing that the assets that were expropriated are back in, he at least ought to then put them back in.
Absolutely, and this all has to happen at the same time. And in a sense, having had this exchange, I perhaps don't need to go to your lordship's passage in the first instance judgment in Taylor Goodchild. But what I certainly pray and aid is the logical connection, the necessary logical connection between those two aspects of the relief. And in this type of case, it's a point I'll come to again and again, but in this type of case, it's impossible to separate the order in relation to what's to happen to the shares with the question of the restoration to the company. Even if the alternative course would be some sort of course of looking ahead, where what one would be left with in the company is the claims, but then one has to value the claims, which is obviously a far more complicated exercise, certainly in this type of case, than simply allowing those claims in effect to be pursued.
I can quite see that the fact that you're seeking a buy-in makes these issues rather more acute.
Yes, yes, yes. The other way round, they would still arise in the sense that, in terms of the notional value, one would encounter the same issue about the practical difficulty of the value of a claim.
Well, if you were, I mean, one situation in which this, if you were seeking a buyout order, either you be bought out, I mean, one way which it would commonly arise is if the petitioner says there has been misappropriation of assets, the court ought to order my shares to be bought out by the respondent, but the court doesn't have to do that. So in the alternative, it could just leave the petitioner in the company. The company could be, but on the other hand, the petitioner would then say, well, at least if I'm stuck in the company, contrary to my primary ground for relief, at least the assets should be restored.
Lord, yes. And so one's left with, again, a logical connection, if a slightly weaker one. But this also goes to a wider point on which I rely, that these are all quintessentially matters for the discretion to exercise at the end of the trial. Of course, this petition does contain, as is usual, the plea at 32.5 for such other order as the court thinks fit. And it's in the nature of remedial discretion under section 996 that there's perhaps a degree of unpredictability about the ultimate outcome, and that involves a balancing of considerations on the facts of the case that will be fully explored at trial.
Well, I mean, it would be possible, I mean, for the court to say, although it's not sought in the defence, but it would be possible for the court to say, well, actually the appropriate order here is not that you buy in, but you are bought out.
Yes, but then it would be necessary then to deal with the value represented by the, as it were, the misappropriation. My lords, Lord, I'm slightly skipping ahead in the light of that exchange, but really, that exchange exposes my first point as to characterisation. This is not a case seeking nothing more than relief that could instead be obtained in a derivative action. It's a case which, on any view, also seeks relief that could only be obtained on a petition. I'm going to refer repeatedly to that distinction and refer to cases in that category, i.e. where the derivative claim couldn't supply the entirety of the relief required as two claim cases, in contrast to what I call purely corporate cases, where a derivative claim as an alternative could serve that function. Lord, my second point as to characterisation is that it is related, that this is a claim of the kind that in my Lord Justice Snowden's first instance judgment in Taylor Goodchild used this phrase that might be described as a corporate divorce claim. It's a type of claim concerning a closely held company, in this case with allegations that it's a quasi-partnership and a corporate vehicle for a joint venture, where the relationship between the shareholders is alleged to have broken down. And indeed, it's a common feature of such claims, certainly a feature of this one, that there are also allegations of what might be called asset stripping or diversion of business opportunities or the like, which are both cause and consequence of the relationship breakdown. And clearly, if behaviour of that kind is established, then it's going to be at least desirable, and usually it's necessary for it to be remedied in order for the corporate divorce to be, as it were, completed. And so that's a point that clearly overlaps with the logical connection between the two aspects of the relief. So, my lords, my lady, those are my 2 points on the characterisation of the issue in this case. And so I turn to my second topic, how in overview I say that the law applies to such claims as regards the relationship between unfair prejudice petitions and derivative actions. And I begin with a number of points that I suggest can't really be contentious on the state of the authorities. First, there's no doubt that wrongdoing in the form of asset stripping or diversion of corporate opportunities, that sort of complaint, straddles the territory of derivative claims and unfair prejudice petitions. The key allegation is likely to be of breach of statutory directors' duties or of other duties of loyalty owed to the company. And the authorities are absolutely clear that such a breach can constitute unfairly prejudicial conduct, even though equally it can give rise to a claim on the part of the company. And I pause to say that I fully accept, and in fact will pray in aid of my submission, it's highly important to the analysis, the conceptual distinction between those two types of claims. The company's complaint is simply of misconduct against it in the form of the breach of the obligation to it. Whereas the shareholder's complaint must be of prejudice to their interests as a shareholder from the breach. That's Charnley Davies, which I'll take the court to shortly. But that conceptual distinction doesn't alter the simple point. The very same act, and indeed the very same legal wrong to which it translates, can be an element in either type of claim.
Well, I mean, at least in a non-quasi-partnership company, it's an essential foundation of a 994 petition to show that there's some breach of the articles, yes, or breach of fiduciary duty or something like it.
Well, yes.
It is possible in a quasi-partnership type case to have no breach of duty or breach of the articles, but to have some other form of conduct which Lord Hoffman described in O'Neill and Phillips as being a sort of breach of an established principle of equity, where the court would intervene to grant relief, notwithstanding there wasn't a breach of contract, if you like.
Well, yes, that I accept.
But the classic type, I mean, this petition is a classic, if you like, in the sense it's just like virtually so many other petitions. Joint venture, two people fall out, one of them claims the other excludes him or her, and then there's a claim that the person who's done the exclusion has set up a company down the road and transferred or diverted the business, yes, as a means of financial exclusion as well as managerial exclusion. I mean,
Yes.
it's just a classic. I mean,
Yes.
there's nothing very unusual about this fact pattern.
Well, no, absolutely, and this is why I put it in terms of a type of case. And as I'll come on to it, as I'll expand on, in my submission, it's a useful way through the principles on the overlap between the two types of claim, where there's perhaps a degree of uncertainty on the state of the authorities. To think in terms of types of claim helps to clarify the issues. In my submission, in this is, as your lordship says, in a sense, an archetypal unfair prejudice petition type of claim. To pick up on another point your lordship raised, yes, I accept that there may be, in section 904, there may be conduct short of a breach of director's duty, say, or legal wrong, that is sufficient to establish a basis for unfair prejudice relief. Of course, in the other direction, what Charlie Davies say, and I also fully accept this, and it's important to the conceptual distinction, is that in the unfair prejudice context, the legal wrong isn't enough, and there's a further element that's required. It needs also to amount to unfairly prejudicial conduct. But
Well, you need unfairness and prejudice.
yes, and so, but in this type of case, of course, the legal wrong will go to the heart of the unfairness and to the evidential basis for that complaint to satisfy the specific requirements of section 994. And Lord, this overlaps in a sense with the point I was just coming to, that in these corporate divorce cases, there's an overlap of remedies as well between the two types of action, but the overlap goes, as it were, only in one direction. And what I mean by that is this, that section 996 of the Companies Act provides for very broad remedial powers on a petition. The authorities have emphasised that again and again. The authorities also leave no room for doubt that the remedial powers extend to orders to compensate the company for other remedies benefiting the company as part of the relief. Again, the conceptual basis of the remedy may differ, but that does not alter the practical effect of the remedy. But to make an obvious point, the same breadth does not exist in the opposite direction. The court is not empowered on a derivative action to grant discretionary remedies of the kind necessary on a corporate divorce to deal with the interests in the corporate entity and separate those interests. It has a much narrower brief limited to remedying the wrong done to the company. And the crucial question then becomes, in my submission, is there any reason why the shareholder should not be permitted an unfair prejudice petition in that type of case to invoke the extended remedial powers provided by section 996 of the Companies Act to seek the entirety of the necessary relief? And I say the necessary starting point must be that Parliament has chosen to enact, in the context of the unfair prejudice remedy, a very broad remedial discretion in section 996. The central reason suggested against me on this appeal as to why the broad statutory discretion should be, as it were, cut down by reference to principle arises from the sort of concern expressed by Lord Scott in Chime about subversion of the rule in...
Just to sort of keep myself clear, you said you got two of your uncontentious points. Is this a third point or an elaboration of the second point?
I'm sorry, my lord. I should have made clear. I'm moving beyond the uncontentious territory.
Yes,
so 2 points that are uncontentious, and I'm moving now to address in
Yes.
overview
The more
points
contentious.
taken. Yes.
Yes.
my lord, the central point arises from the concern expressed by Lord Scott in Chime about subversion of the rule in Foss and Harbottle, as I was saying. And I'll come in due course to Lord Scott's judgment. But the concern he expressed was expressly as to the inappropriate use of a petition. And actually the circumstances he identified as to when a petition will be inappropriate were really rather narrow. Otherwise, he accepted that Section 994, its statutory predecessor, and Section 4559 of the Companies of the 1985 Act, was enacted to enable the rule in Foss and Harbottle to be outflanked, as he put it. The first point to be made about that is that in cases where corporate remedies are sought, the petitioner is not actually bringing the company's claim in contravention of the rule in Foss and Harbottle. The unfair prejudice remedy has always existed as a parallel jurisdiction sitting outside that rule, which enables a claim to be brought on a different conceptual basis. That is, the unfair prejudice to the shareholders' interests. That is the fundamental difficulty, I say, with my own friend's statutory submission, as he calls it, which I will come on to in more detail. The petitioner is not bringing a derivative claim on behalf of the company.
It looks awfully like it, though.
That I accept.
You put in your petition something saying wrong has been done to the company, please compensate the company.
Yes, that I accept. But crucially, there's the conceptual distinction. What I also accept, though, is that there can be an effect on the company's claim, and I accept that that can't be disregarded. In other words, the effects of the relief sought, and insofar as granted in the petition, perhaps if not granted to some extent, may preclude the company from bringing the claim in the future, whether by way of an issue estoppel arising, or because clearly there can't be, the company won't be entitled to a double recovery insofar as it has recovered loss on the petition, or it's been dealt with, as it were, in the context of the petition. Whilst I accept that those considerations can't be ignored, they're again quintessentially, in my submission, matters for the trial judge in exercising the remedial discretion under Section 996. And in that context, proper account can be taken of them. They don't supply a reason as a matter of principle for excluding any possibility of relief that might have that, as it were, side effects. Because clearly in the present type of case, there's very little practical concern that could arise out of that, because these are issues that will need to be dealt with in any event. And it's inherently unlikely, therefore, that it can be said to be abusive or inappropriate in this respect in the two claim cases, or even more in the corporate divorce cases, by reference to that concern about the interaction with the rule in Foss and Harbottle. And that's because in a closely held company in which the shareholders are at loggerheads, it's inherently unlikely that the misconduct towards the company that's alleged won't also amount to unfairly prejudicial conduct or mismanagement, to use the language of Charney Davies, not least because the notion of the company as an abstract entity or a body of shareholders with interests distinct from the individual interests of particular shareholders will inherently have broken down in that type of dispute.
So I'm just trying to envisage a situation in which the claim that the company has had its assets misappropriated, if established, would not give rise to an unfair prejudice remedy. And I can think of at least one straight off, which is, I mean, it may well be said, for example, that yes, indeed, the respondent misappropriated the company's assets in a way that would give the company a claim, but that it's not unfairly prejudicial to this petitioner.
Yes.
Because of his own misconduct. You know, prejudicial, yes, but not unfairly so, because it may well be that the petitioner has been acting inappropriately as well, and there are cases like that. I think it was called London School of Electronics or something, but there's a number of cases where it's said to be a reason to refuse unfair prejudice relief, that the prejudicial conduct isn't unfairly so because the petitioner himself has been acting inappropriately. So you're saying these are different juridical
yes.
jurisdictions, and it doesn't follow that because you could establish a breach of duty and a loss to the company, which the company could pursue in a corporate claim, that it follows that the petitioner automatically gets unfair prejudice relief.
Well, yes, and another type of case where, in my submission, it's far more likely that it's not going to be possible for the minority shareholder to establish unfairly prejudicial conduct merely from a breach of duty by a director to owe to the company is in the case of the widely held company, and if one has a minor shareholder, and the sort of situation, and we'll come to specific examples of this in fact in the authorities, but where you have that type of company, there's a complaint of breach of duty by a director and nothing more. There's an independent board that's considered whether to bring a claim and decided it's not in the interests of the shareholders to do that. The majority of the shareholders have considered the matter and reached the same view. It's going to be much harder, I don't say impossible, but much harder in that sort of scenario for the minority shareholder who's aggrieved by that position to complain that there is unfairly prejudicial conduct to their own interests as a shareholder. To some extent, these matters have to be looked at in the round, and they're likely to have a very different character.
And that's because you say that even though in that scenario there's a breach of duty causing loss to the company, an independent board has decided that it's not worth the candle for the company to pursue it, or there are some other commercial reasons why the company wouldn't want to pursue the cause of action.
Yes, but
so that it, because of that intervening sort of step, it's not unfairly prejudicial to the minority shareholder.
Well, my lord, there's that, but also
I'm not disagreeing with you. I'm just trying to understand that I've just got your example correct.
My lord, that is my example, but there's the additional consideration also of what else is complained of, because if that's an isolated complaint about the failure to, then often the focus will be a complaint about the failure to bring the claim, combined with a specific allegation of misconduct, a wrong done to the company. That of itself may not have the necessary character of unfairly prejudicial conduct. If it's that alongside wider complaints about the way the company has been run, then those same acts of misconduct can assume a different character.
Can I try spinning it slightly differently? So suppose an unfair prejudice petition is brought in circumstances such as you've been envisaging, where an independent board has decided not a good idea to bring the claim, a majority of shareholders have also taken that view. But nevertheless, for other reasons, it's possible to put together a claim of unfair prejudice. Might it then be abusive on your case to seek relief in favour of the company in the unfair prejudice petition, or not?
In my submission, not, because in that example, the petition is not motivated purely by a desire to get around the rule in Foss and Harbottle, because the complaint also concerns the other conduct. If there was no other conduct, then I accept it may be abusive because, and again, there are examples of this in the authority we've come to, but really the only reason, the court can infer that the only reason that the minority shareholder has resorted to an unfair prejudice petition is because they are unable to rely on an exception to the rule, and that's what motivates the petition. But the actual complaint,
it could, in slightly different facts, be an absolutely blatant attempt to get around the restrictions on derivative claims,
yes,
and then it would be abusive.
well, I accept it's capable of being abusive. It's a strong thing to say something's abusive, so I say that it's a rare case. But you could have cases where there really is no feature of the case that points to conduct that has the additional element, as it were, so that it be characterised as unfairly prejudicial towards the particular shareholder, and therefore it can be inferred that what's going on is nothing more than an attempt to circumvent the rule.
I mean, stripping it, taking the word abuse out for a second, I mean, it would just be just a bad claim because,
well yes.
I mean, what you'd say is, okay, here was a breach of duty by a director. An independent board has decided not to pursue the claim for other genuine commercial reasons. You know, they don't want to wash the dirty linen in public, or the director actually is not worth the money, or because there would be reputational issues involved, whatever it is. For a minority shareholder to say no, that's unfairly prejudicial, would effectively be saying that that process that I've just described, which is actually the process that the company's articles envisage, namely an independent board, and which doesn't fit within one of the exceptions to the rule in Fossil Harbottle because the wrongdoers are not in control, wouldn't be something he could complain of because the company's affairs are being conducted in accordance with the articles and in accordance with the fiduciary duties of the majority of the independent board who decided for genuine commercial reasons it shouldn't be brought. So, I mean, it's not really an abuse, it's just a bad claim. I mean, it just doesn't even get past the first of Lord Hoffman's sort of concepts of unfair prejudice, namely it has to genuinely be, or has generally to be, a breach of the articles or a breach of the understanding on which the contractual understanding on which the company is established. So
yes,
I find it difficult. I don't think it gets you very far with calling it an abuse. It's just bad.
Well, that I accept, and I accept there, even if there is an abuse argument, there are the two possibilities. Focusing on, as we're dealing with here, the strikeout situation. I accept the reasons your lordship has said. Those would be reasons why the claim would ultimately fail.
Well, it could be struck out. I mean, it
could be struck out if
it could be struck out simply on the basis it just doesn't disclose a reasonable
yes.
cause of action, which isn't necessarily the same thing as saying it's an abuse. I mean, I think one of those questions is directed at abuse in the sense of trying to sidestep or subvert some other procedural, some other process that Parliament has put there for a particular reason.
Well, yes. I accept that. Of course, what I say though on the strikeout question, that would only be appropriate on the petition if the case but one could see on the pleadings that the case that the conduct complained of amounted to mismanagement was plainly hopeless, and I accept that in the example your lordship gives, that may be the case. Because there's simply nothing more.
I think it was the example you gave to start with, but
yes.
But I mean, we got into this because you were trying to demonstrate, I think, a more limited proposition, which is that you say that a claim brought under Section 994 by a shareholder, which looks like a company claim because it involves an allegation of breach of duty to the company and seeks a remedy that somebody makes compensation to the company, is nonetheless a difficult juridical creature because what the petitioner has to establish under 994 is unfair prejudice,
yes,
not just that there was a wrong to the company which merits relief.
Well, that's right. And so,
And that's where we started this little, I don't know quite
Yes.
where we've now ended up, but that's what we started. That was your starting point.
well, it was my starting point because it's the answer to the objection, a principle based on the law in Foss and Harbottle. In
Well,
the
it's
case
your-
where,
I
in
think
fact,
it's at the heart of your answer to Mr. Robbins' point on what section 260 means.
well, the points overlap because it's in my submission. It's really central to his whole response to the appeal. In a sense, what he calls the common law submission and the statutory submission are variations on this theme. That he says that what is going on where there is an attempt to seek these corporate remedies in a petition is impermissibly to get round the rule in Foss and Harbottle. I say that when one properly considers the conceptual basis of the unfair prejudice remedy, it's not doing that at all. The rule isn't engaged except in very limited circumstances where there's really no other construction that can be put on the petition, but that its only justification is to get around that rule. Whereas if the petition discloses a case of unfairly prejudicial conduct, then it's properly engaging the statutory powers under sections 994 to 996. Again, I'll come to this, but this is really what's being said in Charnley Davies, and in my submission has been perhaps rather understood, certainly by the first instance judge in this case, and to some extent in some other authorities. But really, that's the distinction, that the conceptual distinction that that one needs to keep in mind. And the effect of that distinction, if one has it properly in mind, is that in the case of the sort of case before the court now, it's highly unlikely that there's going to be an objection, a principled objection, based on the rule in Foss and Harbottle. And another aspect of that same objection is a suggestion that what's going on is an attempt to circumvent the permission requirement attached to a derivative claim, rather more specifically. But in relation to that, in my submission, it's important to have in mind what the mischief is, the specific mischief is that originally gave rise to the permission requirement in relation to derivative claims. Just in relation to that, could I ask the court to turn up tab 25 in the authorities bundle? I think it's the final tab in the first volume.
Tab 25.
Lord, yes.
Now, I think that's in the second volume. But,
Oh, I'm so
you've
sorry.
probably got it double-sided, have you? We
Yes,
have.
I have.
Yes. To Waddington.
Lord, yes. And the passage I want to refer to is just paragraphs 50 to 54. That's on the numbering on the bottom right-hand corner, pages 484 to 485. And I simply refer to it because Lord Millett there sets out the history of the permission requirement by way of control over derivative claims.
Could you give me the paragraph numbers again?
Paragraphs 50 to 54.
I'm doing this electronically and the page numberings are a bit out, so it'll take me a little bit of time to catch up.
And really the point I draw attention to is that emerging from paragraphs 52 and 53 in particular, because the situation that prompted the Court of Appeal in Prudential and Newman to arrive at, as a solution to a particular problem, the imposition of a permission requirement was the sort of situation where there was an allegation of fraud on the minorities, the justification for bringing the derivative claim, and determining the truth or not of that allegation of the fraud on the minority might require a 30-day trial when the claim itself would only require a 30-day trial. And so clearly one has an absurd situation, but in particular, the company might still be put to the trouble of the substantive trial, even though it turned out at the end of the 30-day trial that there was no fraud on the minority. So that was the particular mischief which originally gave rise to the solution of the permission requirement. And then after that case, it found its way into the RSC and then the CPR, and then it's become a statutory requirement in the 2006 Act. But there, of course, the only complaint in that type of situation is the failure to bring the claim. And so it's understandable that the company shouldn't be troubled with litigating that issue along with the actual claim. But that sort of objection doesn't arise in the two claim cases, or even less in the corporate divorce cases, because in those cases the court will anyway need to examine the constitutional dispute, quite apart from the question of whether there was a claim that the company could and should have brought.
I mean, to take the obvious, Prudential and Newey was a case brought by a minority shareholder who didn't want to leave the company.
Yes. Yes.
I mean, there was no corporate divorce implication to that case at all.
Yes. Yes. And so the only reason to get into any of those issues that might be given the banner of mismanagement was just in relation to the propriety or not of bringing of the company's failure to bring the claim. And so it's just the fraud on the minority question. It is not part of a wider set of unfair prejudice allegations. And so I say, outside that narrow case, where the only complaint is about the failure to bring the claim, the principal just isn't engaged at all, and the objection doesn't arise. A final point of overview before turning more generally to the authorities. The high water mark of the case against me, and what seems to have informed the approach taken by the first instance judge, is the remark of Justice Bakarian Chime that in a complex case it would be rare and exceptional to entertain a case for compensation to the company on an unfair prejudice petition. I'll submit in due course that that's not reflected by what Lord Scott said in the same case, but I'll more particularly seek to show that it simply does not reflect the position in English law. What is better reflected in the English authorities is the distinction between misconduct and mismanagement as delineating the proper territory of derivative claims and unfair prejudice petitions. But as I've already touched on, the first instance judge was wrong to think that that language implies a narrowing of the breadth of jurisdiction under section 996, and that's always been recognised in the cases. It does not. And even if I'm wrong about that, the mismanagement characterisation undoubtedly extends to claims such as the present one, where the complaints of wrongs to the corporate joint venture vehicle are entirely bound up with the complaints of unfair prejudice to the petitioner's position as a shareholder. and the remedies seeking restoration of assets or compensation to the company are inseparable from the overall corporate divorce. With that introduction, I turn to the authorities rather more specifically. The starting point of my submission is the decision of Mr. Justice Hoffman, as he then was, in the case of Rear Company. That's at tab 14. I'm not going to attempt a volume number if I can be forgiven. Mine entirely differ. And that is a two-claim case and a corporate divorce case. Essentially, the assets of a family company that allegedly been misappropriated. The main wrongdoer referred to in the report as H. I think he was actually, as it were, a son-in-law in the context of the overall family. Had also transferred his shares to offshore companies. And so one particular issue in that case was whether relief could be ordered against H as a former rather than a present shareholder. But the judgment goes rather wider, and the important part of it for present purposes is, again, I'll use the numbering, if I may, at the bottom of the page. It's at page 263.
I have a dreadful feeling that
Yes.
my lady's electronic version
Okay,
doesn't
we
have the
need-
same numbering.
It
So
doesn't.
perhaps
So your 263 is my 260. So I think I'm 3 pages behind you.
Okay, that might my maths
No, I'm
might
3
stretch
pages
to
ahead
that.
of-
So
Yes, exactly. So if we can all
not much further.
work on it together, that would be very helpful.
So page 260 for my lady, and the relevant passage is at D to H. It's accepted that on the facts alleged in the petition, the truth of which remains to be tried, the petitioners would be able to mount a derivative shareholders' action against H in order to require him to account for such of the company's assets as he may have disposed of without authority. And this is the next sentence is the important one in terms of the particular issue that Mr. Justice Hoffman is here considering as well, and which is relevant then to the later cases, rather than the issue about the position of an ex-shareholder. But it is said that such an action should be commenced separately by writ, and that it would not be proper to seek the equivalent relief within a petition under section 459. So it's this question of impropriety about the use of section 994 petitions in relation to relief that could alternatively be pursued by a derivative action. That's the issue that is also the prominent one in the later cases and is considered here. And he says that looking at the matter from a practical point of view, that does not seem to me to be very convenient. These separate proceedings having to be commenced, it would then be necessary for the proceedings to be heard together. I would be reluctant to come to the conclusion that this form of duplication was necessary unless it was clear that the jurisdiction under the Companies Act provisions did not permit the whole matter to be dealt with on a petition. And it seems to me that although it's true that section 462.2 shows that the normal order will be an order against the company or another member, there's no reason why the words should not be given their full effect and allow the court to give relief in respect of the complaint that the company's affairs have been conducted in a manner unfairly prejudicial to the interests of members, even when this would involve giving relief against a respondent who is no longer a member. So I accept the particular point about the ex-member is of a specific relevance to that case, but he is addressing a wider point about the relationship between the two.
and I follow how you put that. Just to be clear, the relief actually at issue is whether or not H, although no longer a member, can be ordered to? I'm sorry, is it ordered to buy the shares or?
It's a little obscure because, and it may be important to note
It's a 262 of the bundle at D, isn't it?
well, it is, but there are differing accounts of it because 262D doesn't purport to describe all the relief that's going to be added or that may already be there. And so certainly the relief that was already there and was sought included an order that H account for payments to the company. And one can see that from the motions at the top of page 282. So an order that H accounts for any remuneration paid to him since November 1982. What may be important to note is the way it's treated in subsequent authorities, because there is a degree of obscurity in that respect, I accept. And so it's certainly true that the particular relief that's being focused on by Mr. Justice Hoffman in relation to the strikeout order is an order sought that H, together with the companies, purchase the petitioner's shares.
But you say you can see, at least from the top of 282, that the relief sought against H went wider than that.
Well, I say that, but I also say that regardless, Mr. Justice Hoffman is considering a slightly wider issue. And when one sees also how it's treated in subsequent authorities, it's that aspect of it that's relevant to those subsequent authorities, and that's how the case is treated.
Yeah.
And one sees that, in fact, this is just the next tab. In the case of Charlie Davies. And this is, as it were, a purely corporate case. It's concerned with Insolvency Act provisions, but for our purposes, they are materially identical. But the claim sought to be advanced was, in essence, just a negligence claim, alleging that an administrator of the company had failed to obtain a proper price for the company's business. And there was an attempt to say that that itself was unfairly prejudicial to particular creditors. It's also relevant to note this isn't any sort of question of amendment or strikeout. It's a judgment after trial. And there's a further point that's important to note about the focus of the judgment, which is that what is, and it relates to the exchange a little earlier on, what the specific question being addressed by the court is not so much when it may be proper to bring an unfair prejudice petition or the type of claim that's brought under the Insolvency Act. The question being asked is what conduct will amount to unfairly prejudicial conduct so as to provide a basis for granting relief. And that's what was relevant here because they got to the end of the trial. And actually, I think it failed in any event on other grounds. But the question being advanced was whether it would be possible for the court to grant relief on the basis of what had been established in terms of the particular conduct that was complained of, which was just a negligence claim. And the important and just to support what I've just said, in the bottom right-hand corner, numbering 284 or 281 on the electronic version, one sees at B to C a summary of the submissions of Mr. Crystal acting there. And it's point 4, that conduct which injures the company itself and all the members and creditors in accordance with their respective interests cannot constitute unfairly prejudicial conduct. And what Mr. Justice, as he then was, Millett, concludes is, I would be reluctant to accept any of those submissions. And then picking it up at the bottom of that same page, he says, an allegation that the acts complained of are unlawful or infringe the petitioner's legal rights is not a necessary averment in a Section 27 petition. In my judgment, it is not a sufficient averment either. This goes to the point discussed earlier. The petitioner must allege and prove that they are evidence or instances of the management of the company's affairs by the administrator in a manner which is unfairly prejudicial to the petitioner's interests. Unlawful conduct may be relied upon for this purpose, and its unlawfulness may have a significant probative value, but is not the essential factor on which the petitioner's cause of action depends.
So just pausing there, I mean, you say that's consistent with the debate
Yes.
that a breach of duty and a wrong committed by somebody in charge of the company, in this case an administrator, usually a director, to the company, is conceptually distinct from an allegation of unfairly prejudicial conduct.
Yes.
It's not necessary to allege a breach of duty. It's possible to have unfairly prejudicial conduct through, in a quasi-partnership company, for example, by exclusion.
Yes.
And it's not a sufficient averment either. That's because you don't get home on an unfair prejudice petition just by saying there was a breach of duty to the company causing loss to the company. You have to show, you also have to allege that that prejudice was unfair.
Yes, in the wider context of the petition, and so alongside other acts. And in fact, that's what the next paragraph rather expands on, because he addressed the question: what more is required to get from the breach of duty to a sufficient basis for unfair prejudice relief? And he says the distinction between misconduct and unfairly prejudicial management does not lie in the particular acts or omissions of which complaint is made, but in the nature of the complaint and the remedy necessary to meet it. It's a matter of perspective. The metaphor is not a supermarket trolley, but a hologram. So
has anybody ever understood what that meant?
I've wrestled with it, and I think that holograms were rather more common.
Well, supermarket trolleys are probably in the news at the moment, but nobody, as far as I'm aware, has ever understood what that meant.
Well, what I suggest in context?
Just that sentence. I mean, it's the sentence that people have puzzled.
Well, I think the key point is the suggestion that if one focuses on the director's breach of duty, it can have a different significance and appearance depending on the perspective from which one's looking at it. And so, in the context of the company's own claim, it may be nothing more and need be nothing more than that breach of an obligation to the company. But at the other sort of level, as it were, of the hologram, it can also constitute the unfair, fairly prejudicial conduct, giving rise to a basis for relief under Section 996. I think he may be suggesting that what one doesn't do is take an item out of the shopping trolley and focus on that. In other words, that item can never change its appearance, no matter what angle you look at it from. And that's supported by the next sentence, because what he says you have to look at is the whole gist of the complaint. And if the whole gist of that complaint lies in unlawfulness of the acts or omissions complained of, so that it may be adequately redressed by the remedy provided by law for the wrong, the complaint is one of misconduct simpliciter. There's no need to assume the burden of alleging and proving that the acts or omissions complained of also constitute unfairly prejudicial management of the company's affairs. It is otherwise if the unlawfulness of the acts or omissions complained of is not the whole gist of the complaint, so that it would not be adequately redressed by the remedy provided by the law of wrong. And I do emphasise what he says about the role of the remedy in relation to this distinction, and whether the remedy made available at law, as it were, as opposed to by way of the discretionary remedies available on a petition, would adequately address the complaint that's made. But in the case where the remedy available at law in the company's claim for breach of director's duty, where that would be adequate, it is not necessary to assume the burden of establishing anything more in terms of the misconduct complained of. But where one does seek to rely on that same breach for purposes of alleging unfairly prejudicial conduct, what he also says at the end of that paragraph, and again I do emphasise this, a much wider remedy may be sought. And then importantly, so I say that this fully supports the analysis suggested earlier, that where you have a situation where you have the allegation of breach of a director's duty, but it is in a wider context of complaints of other matters said to constitute unfairly prejudicial conduct, the character of that alleged breach of director's duty changes, and it supports the allegation of unfairly prejudicial conduct. And if that is satisfied, then a much wider range of remedies is opened up under the Act.
Just to be clear, since you focused on those words, when Mr. Justice Millett says a much wider remedy may be sought, what does that mean?
Well, what I submit it means is that it means that the entirety of the remedies under Section 996 in the present version are then available.
About.
So it would include that and anything else.
And if we skip to the end of the following paragraph,
well, yes, precisely.
Then he's, he, in a sense, he expands on it, because he draws the distinction between people who would be happy with simply an order for restitution to the company, and those who, as he says in the last two sentences of the next paragraph, and he's dealing here with his own case, the case he's dealing with, the petitioners relied on the respondent's unlawful conduct as evidence of the manner in which he'd conducted the company's affairs for his own benefit and disregard for their interests as minority shareholders, and they wanted to be bought out. He's talking about Mr. Justice Hoffman's case.
Yes.
They relied on the respondent's unlawful conduct as evidence of the manner in which he conducted the company's affairs for his own benefit and disregard of their interests as minority shareholders, and they wanted to be bought out. It says just a little bit further on here that they wouldn't have been content with the order for the respondent to make restitution.
Yes.
So I think he's using the facts of Mr. Justice Hoffman's earlier case to explain the rather more Delphic supermarket trolley.
But in this sense, that I'm not really don't know that this matters, but the reference to the much wider remedy doesn't, in that sense, help you, because what he seems to be envisaging is a different remedy rather than an additional remedy. Well,
in my submission, the essential point he's making is that in this type of case, if you have a wider complaint relating to your position as a shareholder in the company, it won't do you much good to have the compensation or the assets restored to the company, because then you'll still be left as a minority shareholder in a richer company. But
it is a much wider remedy, isn't it, in this sense? Suppose you have a company in which the respondent misappropriates assets to the tune of £100, but does so thoroughly dishonestly and lies about it, etc. The petitioner says, look, I can't trust this person anymore. I must be bought out. I'm not going to be satisfied if he just repays the £100. I want him to buy my shares. My shares happen to be worth £500,000 because this is a very successful company, but I just can't exist in it with somebody who is dishonest.
Yes.
I mean, it's a much wider remedy than just £100 being put back into the company. It's saying that the respondent must actually buy my shares for £500,000, which he would not otherwise be obliged to do. It's a different remedy in type, but it's wider in sort of financial impact, if you want to put it that way.
My Lord, yes, but also to provide an additional answer to my Lord Justice Newey's point or question, in my submission, by those words, he's not purporting to address whether the wider remedy would be alternative or cumulative, or how it would work. He's simply making the point that once the conduct complained of is established to amount to unfairly prejudicial conduct, one opens up the court's discretion to do what is just by way of remedy in exercise of the discretion under section 996. And so there are all sorts of permutations on the particular facts as to what that may consist of. And clearly, it's ordinarily going to need to deal with the matters that could also have been addressed just by way of the derivative claim, or that arise from the, as it were, the narrow misconduct.
I mean, that last part doesn't come out of this page to me. I follow how you can say that you see the difference between the narrow claim and the wider one, and the difference in character, and how that leads to a different remedy. It doesn't jump out of the page that what Lord Millett has in mind is that you get the claim in favour of the company as well as buyout. But I'm not saying it matters, but it doesn't jump off the page.
Well, I'm certainly not suggesting that he's endorsing any windfall.
No, but I'm not sure I'm not sure that you can infer from this that he has in mind that there will be any redress in favour of the company at all, because in the standard buyout situation, that isn't a necessary feature.
Look, my Lord, in my submission, he's just not addressing that.
No, he's not addressing. I agree with you.
So,
Yes.
To that extent, I think we're in agreement, and I would perhaps adopt what my Lord Justice Snowden said about then the significance of what he says about Rear Company. And I come back to my point that, in a sense, what may be more significant than what the facts of Rear Company were, which are slightly obscure, but how it's then treated in this passage. And what's important is that there's a recognition that the remedy of compensation to the company won't be sufficient in the two claim type of case. Now, it may be that analytically also, in our case, for example, one has both the allegations of asset stripping, if I can use that shorthand, and the wider complaint of the exclusion from management. And in practice, in terms of the corporate divorce, as we discussed earlier on, those are logically connected and ultimately have to be dealt with together, in my submission. But it may be that conceptually one still holds on to a notion that, in terms of the specific directors' breach in relation to the asset stripping, that is dealt with by a restoration of assets to the company. And then in terms of the wider remedy, that may find its basis rather more in other aspects of the complaints.
I mean, you're obviously
the
taking us through lots of authorities, but in a buyout situation, I mean, the petitioner is going to leave this company. He doesn't care whether the company's got the money in from a wrongdoer or not. What he wants is a price that reflects the value of the claim. And he can get that by a buyout order that doesn't feature at all any remedy in favour of the company.
Well, but it may not be very convenient as a matter of how that would operate in practice, because one still then, even in that situation, one needs to arrive at a value for the claim, which is ultimately, well, you have to value the claim in circumstances where actually what the value of a claim ultimately turns out to be is, in a sense, binary. And so that manner of approaching the problem may be a rather impractical one.
But isn't that just a question of valuation? I mean, I can't see why the petitioner who successfully gets a buyout order is going to have the least concern with an order being made in favour of the company, or why anybody would make an order in favour of the company. I mean, he just wants the value of his shares.
Well, that may well be the position on the particular case, but in my submission, that wouldn't be a sufficient basis for imposing some limiting principle, because all these things have to be considered in the round at the stage of exercising the remedial discretion. And so it's going to ultimately depend on the appropriate order in terms of the direction in which the shares go in, and or whether some completely different form of relief turns out to be the appropriate one on the particular facts. So it wouldn't be appropriate, in my submission, to rely on...
To shut it out at the first stage.
Yes.
Yeah. And in any event, you want to buy in, which you say is different anyway.
Yes.
Yeah. On the buyout, but to pick up on Lord's point, I mean, it must be right, surely, that if the court concludes ultimately that there has been misconduct, misappropriation of assets sufficient to warrant a buyout order, i.e. that the petitioner is bought out, well, it must be right, surely, that the person who's leaving doesn't really care the condition in which the company as a corporate entity is left once he's gone. What he just wants is an accurate estimation of the amount which he's to be paid, reflecting the value of the claim, which is just a matter of valuation evidence. It will, establishing that there was a breach and then valuing the claim.
Yes.
I would have thought that the real issue is the point you touched on in the exchange right at the end, which is when you're putting your petition on paper, you can't be guaranteed that you will get a buyout order.
Yes.
And so more often I would have thought that the point in those sort of scenarios is, I want a buyout order based upon this expropriation of assets or whatever it is. It may not be quite so dreadful. It may just be a perfectly honest, but nevertheless a breach of fiduciary duty, which the court takes the view doesn't justify a buyout, but nonetheless would warrant the money being put back in because the person's going to be left in the company.
Yes.
I mean, it's easy to talk about it in terms of the caricature case where, as night follows day pretty much, if there's a dishonest breach of fiduciary duty, the buyout order will be made one way or the other. But there are many cases where what's alleged is actually a more subtle breach of fiduciary duty, which actually doesn't involve any sort of wrongdoing in the gross sense. It's just it's the Boardman and Phipps type breach of fiduciary duty.
Yes.
In which case it may not be appropriate to order a buyout, which may be a very different consequence financially to the amount of the misconduct. But nonetheless, the petitioner who's left in wants the money put back in.
Yes.
So I mean, it's the stage at which one has to consider this. And
Lord, yes.
if you're putting forward the petition, you can't assume you're going to get the buyout order, therefore not bother to pursue the restoration. I think that's the argument.
Well, yes, and there is the additional point in my submission that a petitioner may want, and it would be legitimate for the petitioner to want, to have the company's claim, as it were, dealt with in the petition because of the practical problems that can arise in evaluation. I fully accept the point that if they have their shares purchased, they don't really care what happens to the claim after that. But they may nonetheless consider, and one has an analogy to this maybe in winding up of partnership cases, about the extent to which a party can say that they want the market to be tested about the value of partnership assets rather than having them valued by the court, because that may be an inherently problematic exercise. And so in this type of situation, there's the additional consideration that, and in a sense all the more so when one doesn't know what direction the shares may go in, but a petitioner may also say, well, the circumstances of this particular claim mean that it may be quite difficult to value.
But you're not going to put it out to the market. So what you're postulating is not putting it out to the market, as far as I can see, but deferring the buyout order while you undertake an account or a claim for compensation, while you do the arithmetic of the claim for the account of profits, or do the arithmetic of the claim for compensation, which you would have to do in a claim by the company against whoever, and you undertake a tracing exercise. All that, on this hypothesis, would have to come before you valued the shares, would it?
Well, I suppose the basis of the submission is the need to avoid a situation in which one's just left with an unknown.
Well, the only way you avoid the unknown is by fighting out in full the company's claim to the point where you establish what is or isn't held on trust, what can be traced, what the account of profits would yield, or whether it's preferable to go for a claim for compensation instead, and if so, what the compensation is. So you're putting off a long way down the road the valuation of the shares that would come with the buyout.
Well, except that on the footing that the claims are being pursued alongside each other.
Except if you were doing this, as an ordinary corporate claim, you might well do liability first, and then there'd be a question of choosing between an account of profits and compensation. Accounts and inquiries would be ordered.
But in my submission, where this type of analysis goes is that clearly the factual permutations are important, and they raise issues of case management. It wouldn't be right from these types of considerations to derive as it were, a barrier of principle. It must be right that a petitioner can say on the right facts that it is far preferable for these matters to be dealt with at the same time. In a sense, it goes to the question that arose in the Taylor Goodchild case about the distinction between whether it was possible to pursue both or whether one had to pursue both. And these should be open to the petitioner to take a view on the facts of the particular case, and can always be dealt with by way of case management in the ordinary way. If then one aspect of the claim is going to drastically slow down another aspect of the claim, clearly that can be dealt with by way of ordinary case management powers. So I say that really the approach in Charlie Davies is entirely consistent with the position in Rear Company in terms of the two claim cases. If the petition isn't just seeking the remedies that will be available at law, but seeks a wider range of remedies,
Well, it would be
discuss
surprising,
that point.
surprising if it wasn't the case, because Mr. Justice Millett thought he was agreeing with Mr. Justice Hoffman as he then was.
Well, Lord, yes, but in my submission, that's an important point because, well, the first instance judge said rather glossed over that in being rather dismissive of rear company and interpreting Charnley Davies as imposing a rather narrow approach based on how he then defined the distinction between misconduct and mismanagement, which was essentially to take the position that if there was a complaint of misconduct in the sense of a breach of duty claim, that demonstrated that those matters had to be dealt with in a derivative action. That's not what it's saying at all in my submission.
Just, I see we're coming up to 12 o'clock.
Yes.
You're covering a lot of ground. You're dealing with numerous questions from the bench. Can you just keep in mind that I think you must finish this morning?
Lord, yes, I understand that, and I will endeavour to speed up. Lord, and I say that there's another, as it were, two-claim case of Re Fahey, where very much the same approach is applied to tab 17. And perhaps in view of the time, I'll just say for the court's note that really that follows the approach set out in Rear Company and Charnley Davies, and essentially reiterates the flexibility of the court's approach and the breadth of the section 996 discretion, and on that basis that it's perfectly appropriate to deal with as it were, the corporate elements of things on the side. That is the position that's firmly established before Chime. In my submission, on proper analysis, it's not materially altered by Chime, at least if one's focusing on the judgment of Lord Scott. Chime is at tab 20. It was a case concerning an application to amend an existing petition. In my submission, that's not entirely without relevance to how it's to be understood, because in my submission, and this is reflected perhaps in the way Lord Justice Voss referred to it in the Apex case, the rather unusual facts of this case are important to an understanding of it, because it's clear that Lord Scott had a great concern about what was going on overall in this in this litigation, and in particular in relation to that, the petitioners were administrators pendente lite of an estate of Mr. Wang, who controlled Chime, and the administrators alleged that his widow, Mrs. Wang, had issued shares to gain control of the company, prejudicing, they said, the estate. And what was happening at the very same time was that there was litigation ongoing as to who was beneficially entitled to the estate. Mrs. Wang was contending that she was beneficially entitled to the estate. And so, of course, if her position was vindicated in the probate proceedings, that would render the dispute as to who controlled Chime between Mrs. Wang and the estate academic, because the whole would anyway ultimately be owned by Mrs. Wang. So that's what Lord Scott is referring to. I draw attention to this because it's my learned friend quotes it in his skeleton argument, but when he refers to the topsy-turvy nature of the petition, and that the real dispute was about the ownership of the goose, not the golden eggs, he's saying the real dispute is as it were, the higher level of the ownership of the dispute. that topsy-turvy comment for the court's notice at paragraph 60 in Lord Scott's judgment. He's not there making any sort of comments on the relationship between two types of claim. If I can deal first of all with the judgment of Justice Bakari. So I say, in a sense, this is the high watermark of the case against me. And paragraph 27, he addresses the jurisdiction. He says there is jurisdiction in the theoretical sense, adopting the distinction expanded on by Lord Scott. And he says, actually, there's also jurisdiction in the wider or practical sense. But in respect of the latter, the use of that jurisdiction would, in any case of complexity, be rare and exceptional. Now, I make the following points about that. First, Lord Scott does not say that. And in my submission, what he says in substance is something very different, and I'll seek to make that good in just a moment. But secondly, that statement has at no time been adopted as a matter of English law. Again, I'll seek to make that good by reference to subsequent cases. I draw attention, though, also to two particular points made by Justice Bakari in support of his principle. First of all, paragraph 25, he refers to an English case, Atlas View and Brightview. And what happened in that case was that there was an order for compensation directly in favour of the petitioners, and it's he draws attention to that having immediately provoked concern from Lord Scott. And I draw attention to this because in my submission it's relevant to understanding aspects of Lord Scott's judgment. He was particularly concerned about this point, and in my submission it's an understandable matter. What happens if there's a compensation order made in favour of the petitioners, and where does that leave the creditors of the company? And it's a point that came up again in the to some extent in the Hutt Group case. In my submission, it doesn't really bear on the question before the court. It's another matter that can readily be dealt with at the level of the court's remedial discretion. And it may well be right that it would ordinarily be inappropriate.
You would think ordinarily it would be inappropriate, wouldn't you?
Well, I accept that. I accept that. But in my submission, it ought not to have any sort of wider import for the question of principle that we're concerned with here. And yet it reappears in Lord Scott's judgment in a way that I suggest indicates it did in his mind. Secondly, and I draw attention to this again because of the way it was quoted in my Lord Justice Newey's judgment in Taylor Goodchild, he refers to the concern that you might have a situation where there's a relitigation of an allegation pursued in the petition unsuccessful, and then you might have a situation where the company seeks to bring that claim again. And how can it be right that the directors are exposed to that relitigation? But in my submission, it's hard to see how that would in practice be justified, because in the ordinary case, the company will be a party to the petition. And certainly there'll be a privity of interest that will have the effect that it won't be open to the company subsequently to relitigate if there's a change in the in the control of the company, points that have been dealt with and dismissed in the context of previous litigation to which the company was anyway a party. And in any event, it would only arise in quite a narrow set of factual circumstances. Against the background of those 2 points, I turn to Lord Scott's judgment, and it's not an easy judgment to follow in some respects. I respectfully submit. He draws the distinction between theoretical jurisdiction and jurisdiction that, as he puts it at paragraph 40, accords with settled practice about how it should be exercised. At 42 and following, he then addresses what must be regarded as the settled practice by reference to the sorts of cases that I've referred the court to already. I draw attention again, though, at paragraph 46. He refers there himself to Atlas View and Brightview, and again repeats this concern about the inappropriateness of compensation going directly to the petitioner. He then turns to paragraph 48 to Charnley Davies, and he summarises the position in relation to that. He accepts the submission that if the essence of the complaint being made was of director's misconduct rather than of director's mismanagement, judgment stands as authority for the proposition that the proper vehicle for seeking and obtaining such relief would be a derivative action rather than a petition. Well, I don't quarrel with that statement, but of course it needs some unpacking by reference to the submissions I've already made about how that distinction actually operates, and in the context of a petition. And so I say that the first instance judge, as I've already submitted, imposed far too strong an effect on those words as somehow narrowing the jurisdiction. And it becomes clear from the remainder of the judgment that that is not what Lord Scott intended to achieve by that statement. He says at paragraph 49, having referred to those various authorities, on these authorities, as well as a matter of principle, I conclude there would be jurisdiction in the strict sense on the hearing of the petition, the court's grant of relief sought under the amendments. I do not regard that of excuse me, disposing of the issue as to whether it would be appropriate to do so. Lord Smith, in my submission, he can't be suggesting there that the authorities he's been addressing are only dealing with the jurisdiction in the strict sense, as he puts it. That just can't be right, because those are all cases which were concerned with the exercise of an actual jurisdiction, and his own, Lord Scott's own definition of the distinction between the strict jurisdiction and, as it were, the principled jurisdiction, emphasises settled practice as being the crucial element in terms of the exercise of the discretion. So
I slightly wonder whether when people say settled practice, they quite mean it. And he himself says, he talks about what's proper. You sort of move from whether it's really settled practice to whether it's proper. But anyway, that's by the by.
Well, and there is the danger in my submission that I accept, of course, that discretions are always bounded by principle. But there's a danger that the distinction between these two notions of jurisdiction can can confuse the position rather than clarify it. And it may be better to think to pose the question in terms of whether there are principles that constrain the exercise of this particular discretion. And but in a sense, my short point, though, is that he shouldn't be taken in this judgment to have been disagreeing with that earlier body of authority. And that does become clearer in my submission as well when one turns further in his judgment, because there's then a passage where he addresses the facts, and he emphasises the horrendous cost of the litigation and so on and so forth in relation to this proposed further claim in relation to a loan that then may all become redundant depending on the outcome of the dispute about the ownership of the estate. He then comes back to questions of principle at paragraph 62, and he makes an observation that he really states 2 points of principle. He makes an observation that the court should not make an order which does not correspond with what would be ordered in the company's claim. And in my submission, that has
That's the
to be seen.
activist view type point.
Exactly. And so, in terms of points of principle of broader application, it's really just the second point. And the second point is simply that the prayer and the petition for the compensation or restitution to the company shouldn't be left to stand if it's not clear that it can be dealt conveniently. Can be dealt with conveniently at the hearing of the petition. Well, when one puts that in the context of the body of earlier cases that he's considered, and the effect of those, which, beginning with Mr. Justice Hoffman's judgment, is all about really considerations of convenience, that is where he lands. And so there is no strict line drawn or narrowing of the breadth of the jurisdiction by reference to a principle. There's really just a point of, as it were, case management. And that's clearly a highly pertinent consideration on the particular facts before him, where there were these actually quite extraordinary reasons why it would be highly inconvenient as a matter of overall justice to add these very large further claims onto claims which already may be entirely redundant. And
I mean, that's the fact. Your point is that in reality, this is all about case management of a much wider dispute.
yes,
I mean, hence the golden goose and golden egg. I mean, I think I probably ought to disclose. I think I was Mr. Potts's junior in this case, but not appearing in Hong Kong. I have a distinct recollection of this case, or at least the background to it. But in any event, you're saying that you've got to put these comments into a much broader context in this particular case. It just wasn't convenient to allow the misappropriation, the CAL allegations as they were called, to be dealt with at the same time as the allegations about the share issues. Because if it turned out that in the separate family proceedings that Mrs. Wang in fact owned the company as a whole, none of this mattered.
precisely, Lord, precisely.
And that's why perhaps in this case the court would have been prepared to see something which is an unusual situation, which is two sequential sets of proceedings, namely the unfair prejudice proceedings first, followed by corporate claims being brought second in the second set of proceedings. This was already just a massive piece of litigation, and it was trying to disentangle it rather than the standard sort of unfair prejudice petition which we're looking at in this particular case, which is you very much want everything dealt with in one it to avoid inconsistent judgments and minimise expense. I mean, that's your submission. I think I've got.
Well,
as
that's
I've got it.
precisely my submission. Plus this more, that this case is sometimes treated, I think, as the moment of a potential change of direction in the law on the precise point, really, that the court's concerned with on this appeal. That might have justification by reference to the comment of Justice Bukhari.
And to be fair, certainly all the other members of the court, apart from Lord Scott, I can't remember whether he does too, agreed with Justice Bukhari.
I'm not sure he says that in terms.
I can't remember whether Lord Scott does or doesn't.
I don't think he does. I think the rest of the members of the court say they agree with both.
Yes.
But Lord Scott
Goes his own way.
goes his own way in my submission, and that's, in my submission, that's quite important. And I'll return to this in Gamlestaden, because he doesn't refer. He only refers to his own judgment in Gamlestaden.
Yeah.
And so, on close analysis of his judgment, in my submission, one can't find any statements of principle that should be taken as indicating a change of direction in terms of the principle. The only principle, other than the quite specific point, the first point of paragraph 62, is just this consideration of convenience. And that becomes clearer, actually, if one reads to the end of paragraph 64, from paragraph 63 and 64. But to summarise, he acknowledges the point. He quotes what by then Lord Justice Hoffman says in Saul Harrison and Sons about the precise purpose of the enactment of section 459 being to enable the courts in an appropriate case to outflank the rule in Foss and Harbottle as being one of those purposes. And then over the page he says, the outflanking would not, in my opinion, be appropriate unless the criterion suggested in paragraph 62 were met. Well, he's saying other than that, it is appropriate. And other than on that very narrow point, the only other criterion is simply one of convenience, which is entirely in line with the position already established. And in my submission, that is also how one can then understand what otherwise perhaps appears rather confusing about the way he treats his own judgment in Gamlestaden. That's tab 24. Of course, a Privy Council decision in respect of Jersey legislation, but which is materially the same. And the relevant passage really is paragraphs 26 to 28. And he refers to Chime, and as I've already drawn attention to, he only refers, in fact, to his own judgment. The crucial point is, he says, the Court of Final Appeal held that the court did have power to make such an order, and that's to say an order for the payment of damages or compensation to the company. See the judgment given by Lord Scott. And my learned friend says that's just a reference to a theoretical jurisdiction. Well, again, in my submission, that can't be right. This is dealing with an actual case. And indeed, in terms of how that's then transmitted further into English law, one has the decision of Mr. Justice Briggs, as he then was in the Sikorsky case. And just in view of the time, I won't seek to take the court to it, but paragraph tab 29, it's paragraph 71 where he treats what's said in Gamlestaden as authoritatively laying down that it is open to the court to make orders of that kind. Again, it can't be explained in terms of some sort of theoretical jurisdiction that can actually be exercised. And then the judgment of Lord Justice Voss in Apex, again, I think in view of the time, I won't take the court to it, but I'm sorry, perhaps if I may just very quickly, so it's tab 34. And paragraph 119, he deals with chime, and he treats it as very much a decision on its own facts. The essence of the decision was that where the central claim was an action by the company to be compensated for direct speech, a minority shareholder should not use Section 904 as a way of circumventing the rule in Voss and Whipple. As I've submitted, I don't disagree with that in any way. It seems to me that the decision was simply an application of principle I described in a particular situation. The facts are very far removed indeed from this case. And then paragraph 125, having conducted his review of the authorities, he makes his point that the authorities all speak with one voice. And my submission, that supports my submission. There's not any change of direction in the laws resulting from chime. They show that sections 9946 provide a wide and flexible remedy, and artificial limitations shouldn't be imposed. Pausing there, what would be an example of a situation where the central claim was an action to be compensated for a director's breach? They're already been exchanged with the court as to that. But there are examples, actually, my learned friends' authorities, in, for example, the Jersey case of prestigious nominees. That's at tab 32. And perhaps if I could just summarise the position very quickly and then go, as it were, to the punchline. But this was a case brought by a minority shareholder holding just 2.84% of the shares in the company. The minority shareholder complained about payments authorised by the directors of the company to a number of entities, but the board didn't agree that it was in the interest of the company to pursue litigation, and nor did the overwhelming majority of the shareholders. One sees that from paragraphs 13 and 14. What the minority shareholder then did was commenced a petition seeking authorisation of bringing of the claim on behalf of the company in respect of the alleged wrongful payments, as well as prayers in relation to the actual payments. Once he said at paragraph 21. And the punchline in that situation, one sees at paragraph 51, Mr. Young maintained that we were concerned with the case of mismanagement of the affairs of the company, which was ongoing, but we disagreed. At the heart of the case is the complaint that some 5 years ago 10 payments were authorised by the directors improperly. Applying charmly, however, the matter can be addressed by the remedy provided by law for the wrong, namely the issuing of proceedings against JTC. The complaint is one of misconduct simpliciter. It should therefore have been brought by way of form of claim. It was an abusive process, in our view, for Prestigic to circumvent the rule in Foss and Harbottle, the exceptions to which it did not seek to argue it came within by use of a petition. So there's no corporate divorce type of issue there. There's no attempt by the shareholder, very minor shareholder, to exit the company. There's simply an attempt to get round the decision of the board and the majority of shareholders in relation to the refusal to pursue a loss claim and nothing more. And that is where the point of principle, the objection of principle to the use of a petition can be engaged. And similarly, indirectly perhaps, the decision in Waddington, I suggest, is a further potential illustration of that principle. Certainly that decision in my submission isn't itself indicating any change in the direction of the law, because the context of what the court was concerned with there was, of course, about the permissibility of a multiple derivative action. And so in the judgment of Lord Millett, where this point came up, he was specifically addressing whether an argument against permitting a multiple derivative action was that there was some alternative remedy available by way of an unfair prejudice petition. And so, and the relevant passage is at paragraph 77. And so the starting point there is you have nothing more than a claim of the company. And all he's saying is that if you have nothing more than the claim of the company, it can't be assumed that the aggrieved shareholder, whether the shareholder of the shareholder, can't simply use a section 994 petition instead, and therefore there's no justice in permitting a multiple derivative action as a form of remedy. And in my submission, there's no suggestion that it goes any further in terms of addressing the breadth of when that objection will be justified. Finally, on this front, just by way of a further illustration, the case of Shuntack Holdings, tab 26. And this is a pure corporate case again. And it's a petition, it's not a Hong Kong case, it's a petition in respect of a company listed on the Hong Kong Stock Exchange, rather similar to the Jersey case. What was sought was an order requiring the company to commence litigation where its independent board had concluded that it was not in the company's interest to do so. And there's consideration of a number of the authorities I've made submissions on, but the important point is, I could just take the court to paragraph 55, that's at page 508 on the bottom, or 505 in the electronic section. judge says is one of these exceptions, with one exception, none of these authorities involved a situation where the sole complaints a breach of duties owed to the company, and the only relief sought in the petition was to provide a remedy to the company for misconduct, namely an order for proceedings to be brought by the company. And it's in that situation that paragraph 68, the petitioners have offered no valid reason why the safeguard of the filter should be bypassed in this instance. In other words, the safeguard of the filter in respect of bringing a derivative claim. It is difficult to see what positive benefits they could gain by pursuing the complaints in a section 168A petition or unfair prejudice petition, other than avoiding the filtering process. And so that was reasoned in terms of abuse. But the simple point is it's confined to the situation where there's really no explanation for resort to a petition other than to try and circumvent the requirements of derivative action, because all that's sought is what could be sought in the derivative action. And then I turn very speedily to recent cases, the Hutt Group and Taylor Goodchild. The Hutt Group, first of all, first instance decision is at tab 43. And the first instance judge summarises the principles at paragraph 46, and he puts it in terms of the misconduct, mismanagement distinction. And again, I don't quarrel with that, subject to my submission about how that operates in this type of case. And then paragraph 56, there is an application of that sort of approach on that particular petition, and he refuses to strike out any of the relief. He says the petition is correct to say the claim is properly be seen as one seeking redressment by prejudice. Complaint is in respect to the conduct of the affairs of the first respondent and the effect of that conduct on the petitioner's interest as a shareholder. The fact that the allegedly wrongful conduct includes breach of duties of the directors does not without more mean the claim is a derivative claim. Instead, the nature of the claim must be considered. Subject to consideration in paragraph 4, the petition is not seeking to recover damages for a loss suffered by the first respondent, and there is no suggestion that the first respondent has suffered loss. Pausing there, I think my learned friend seeks to place emphasis on that. In my submission, that's not to be taken as anything more as a reason on the particular facts why there wasn't a pointer on that basis in a particular direction. If there was if the petition was seeking to recover damages for loss suffered by the company alone and nothing more, then maybe one would be up into the sort of territory indicated by the cases I've just taken the court to. But what's important is what follows. It is clear that when the body of the petition is considered, the complaint made relates to the impact of the alleged actions on the petitioner as shareholder, rather than the impact on the company. And similarly, when regard is had to the relief being sought, the primary relief consists of a number of orders against the company, against the first respondent. Such relief patently is not relief which could have been sought in a derivative claim. And so again, one sees the same principle emerging, and that passage is endorsed by the Court of Appeal in the judgment of Lord Justice David Richards, where paragraph 45, he says these cases affect sensitivity, refers to the central point in that particular case, being that while the petition alleges breach of directors' duties to the company, it does not allege that the company, as opposed to Zedra, has suffered any loss. But he endorses the entirety of the passage. I've just taken the court to paragraphs 44 to 45. Whether he puts it in terms of whether the substance of the claim is for the benefit of the company, which reflects the first instance judge's summary of the position. One looks at the petition as a whole and looks beyond a particular claim to see the purpose for which that is really sought. Is it really sought to remedy a loss to the shareholder?
I mean, Judge Eyre, as he then was, just said at 60, the petition isn't a concealed derivative claim, and I'm not going to strike it as an abusive process on that basis. I mean, that's a very pithy way of looking at it. I mean, if we're actually putting this in terms of abusive process, there has to be some sort of furtive or concealed attempt to sidestep the safeguards that are there for a purely derivative claim. But if you've got something which isn't a purely derivative claim, and which actually has as part of its substance, or as the entirety of its substance, an unfair prejudice claim, then there's no jurisdictional bar to having a quotes company claim included within it. I think that's what you're basically saying.
Precisely.
I mean, in a way, I just wonder whether this case, either in front of Mr. Justice Eyre or the Court of Appeal, takes one anywhere at all.
My Lord, yes, and in fact, my submission to some extent, I've already made it, but actually, the law has been pretty consistent on this. I think there is a consistent strand right from the judgment of Mr. Justice Hoffman, right through these decisions. There's no real change of direction at any point.
And I see how you put it, but really they're not dealing with our situation.
Well, our situation is one in which really the court, in my submission, ought not to have to inquire very far into the detail of the petition to conclude that we're plainly within the territory that is appropriate on a petition. There could be other cases where there is a need for a slightly closer scrutiny, but in this category of case, the corporate divorce type of case, the multi-claim type of case, it's inherently unlikely that there'll be either any abuse or that the petition can be characterised as simply concerned with misconduct and in that sense somehow a disguised derivative claim, so that it would plainly be hopeless, even if one's not putting it in terms of abuse. And in a sense, that's the long and the short of it. Very briefly, Taylor Goodchild. I approach this with a degree of caution, but
Not so much as I do. Not so much as I do.
I suspect the punchline is that this doesn't really say anything either. But
well, well, the way I put it is that obviously I gratefully adopt the observations made in the first decision of Lord Justice Snowden in paragraphs 46 to 53, and in my submission that does accord with the established position. In terms of what then the Court of Appeal was addressing, it emerges in a number of places, but if I can just quote the first paragraph of judgment of Sir Nigel Davis, in jurisdictional terms, I can accept that Mr. Goodchild could have sought to introduce into the unfair prejudice proceedings the derivative claims in respect of the Whipple account of profits claim. So he accepts that that's not in question in either judgment. The real question, as I see it, is whether he should have done so, such that his failure to do so renders an abuse of process the subsequent proceedings brought by the company raising these claims. So, in my submission, therefore, the
I mean, this case and that one are sort of opposite extremes.
yes,
In this case, the question was whether they had to do
well, precisely.
what in this case you're told you can't do.
Well, precisely, and therefore, in my submission, my Lord's discussion at paragraphs 29 to 35 of the judgment need to be seen in the light of a question as to the sorts of arguments that might have been thrown at any attempt to bring that claim at the earlier stage by way of justifying the decision not to do so. And of course, I don't suggest that all these claims have to be brought together. I simply say that they can do. And indeed, your Lordship was vindicated in that even on our facts, these arguments have been thrown against us. But whether they're actually correct or not is, at least in relation to our claim, what the court is considering now rather than what it had to determine in that case.
And for what it's worth, I really don't think we were purporting or attempting to decide the issue that arises now.
Well, yes. Lord, I've left myself only a short time to deal with what my learned friend calls the statutory submission, but in a sense, my submission in response to that very much reflects the themes of what I've already been submitting as to the characterisation, the proper characterisation of the unfair prejudice claim. The question that arises is, has the 2006 Act changed the position? Could I just ask the court to turn up section 260, that is in tab 2. And really my submission is a very simple one, that what this section does is sets down the circumstances in which a member of a company can bring a derivative claim. That is a claim there defined as a claim concerned with a cause of action vested in the company and seeking relief on behalf of the company. And then a claim of that kind can only be brought under Chapter 1 of Part 11. But of course, a petitioner seeking relief under Section 994 is not bringing a derivative claim. The petitioner is bringing the shareholder's own claim to remedy the unfair prejudice to the shareholder, not on behalf of anyone else.
I mean, I see how you put it. Just in terms of the language, it applies to proceedings. Well, there are proceedings by a member of the company. They're brought by a member of the company. You're seeking relief on behalf of the company in that you're seeking orders under which money would be paid to the company, or there would be declarations in favour of the company. And the cause of action in respect of which those orders would be made are vested in the company.
Well, I'd accept the first and second of the stages of that. I wouldn't accept the third or fourth. The petition is not seeking relief on behalf of the company.
It's seeking relief for the benefit of the company, but as a consequence, you say, of unfairly prejudicial conduct to the shareholders, and the cause of action is that given by Section 994.
Well, yes, and in my submission, there's a crucial distinction in this particular context between for the benefit of the company and on behalf of the company, because on behalf of the company needs to be read conjunctively with A, i.e. a cause of action vested in the company.
Well,
So it's where
you're distinguishing the position, if I can just sort of cut across you for a second, you're distinguishing the position in your petition which says the company is a nominal respondent to this petition. I am bringing this petition in my own right as 994 petitioner. I seek relief which will benefit the company in respect of a wrong done to the company. But it's different, for example, from the remedy which section 996 itself envisages, which is where somebody will be authorised to bring proceedings on behalf of the company at a subsequent stage. So that's different from what I'm doing.
Precisely, my lord.
Yeah.
And there's no question in the petition of asserting a cause of action of the company. And one's brought back to the conceptual distinction in Charney Davies, which is crucial in this context also. And the submission I made right at the beginning, which is that I accept, of course, that the effect, that the petition may have an effect on the actual cause of action of the company. It may mean that that cause of action ceases in practice to be available because of the remedial orders made or because of issue estoppels arising. But again, those are matters for the exercise of the remedial discretion under section 996. It doesn't transform in any way the nature of the claim being brought in the unfair prejudice petition. It's not the company's cause of action. It couldn't be, because as the Act says, the cause of action is vested in the company. But as the authorities show, that doesn't affect the availability of relief under the cause of action vested in the shareholder under sections 904 to 996, which may achieve the same effect as the pursuit of a derivative action. So that's the principal point. It's a simple one. I also say, of course, it would be surprising if this was this change had been brought about by sidewind. And I say for that further reason, it certainly shouldn't be construed in that way insofar as there's any doubt in the matter. But first of all, it's worth noting in this context also the history of the permission requirement. In a sense, it's not a statutory innovation of the 2006 Act to have a permission requirement, because it was already in the rules of court. But the history of it goes well before that, as set out in the passage of Lord Millett that I took the court to earlier in Waddington. Relatedly, I make the point that my learned friend describes this part of his case as a statutory submission in contrast to what he calls a common law submission. Respectfully, in my submission, that's not quite right, because one's concerned in relation to the existing cases with authority on the exercise of a piece of statute, the statutory discretion provided by section 996 of the Companies Act. And so the question is, can it be right, as my learned friend's case requires, that the 2006 Act actually greatly narrowed the scope of that statutory discretion? Well, in fact, what the 2006 Act did was to reenact that statutory discretion in respect of unfair prejudice petitions in, for all relevant purposes, identical terms. And that's a further reason why my learned friend's argument must fall down. And again, in application of well-established principles of statutory construction, if there's already an established body of case law about a statutory provision, and then that's reenacted, that strongly favours the notion that Parliament intended to reenact it with the same meaning established by that case law. And both points apply to this in my submission, Parliament won't be taken to have, as it were, cut down the extent of a power by a side wind, as it were, and that's clearly what would be happening in this case. And there's no indication in the pre-statutory materials that there was any intention to do that. And indeed, none of the authorities have suggested that there's any material change. I accept it doesn't seem to have been, it's not a point that has been specifically raised. So I accept in theory, it can be a point that everyone missed, but it's a surprising proposition because this has come up again and again. And one sees in cases like Apex, the breadth of the statutory jurisdiction or discretion under section 996 being emphasised just as strongly in respect of the 2006 Act as the earlier cases do in respect of the 1985 Act. So, Lords, my fifth topic, which is confined to 5 minutes, is, in a sense, by way of summary and conclusion, why the judge got it wrong in relation to this particular case. And my submissions on that have run through the entirety of my submissions. But if I can, in a sense, summarise, first of all, the exceptionality test applied was in my submission plainly wrong. That just doesn't have support in English law. Secondly, I say the approach the judge should actually have taken was that in a case of this sort, a two-claim case, or even more, a corporate divorce case, that one didn't need to look far at all to conclude that it was well within the realm of what is permissible in a petition within the boundaries established by the cases. Thirdly, if that somehow involves too broad a standard and one engages in the type of exercise one saw in cases like the Hutt Group of characterisation, it's plain that this petition falls on the right side of the line. That's essentially because, firstly, the asset stripping misconduct is inseparable from the complaints of mismanagement, exclusion from management, failure to provide information in the context of a corporate joint venture. And secondly, and perhaps most importantly, the relief in this case, the corporate remedies, not only are they not the sole remedies, but they're not self-contained either. They're part and parcel of the remedies sought for the shareholder. They seek to restore value to the corporate entity alongside an order to acquire the respondent's shares. And fourthly, the first instance judge plainly, with respect, misapplied any sort of consideration of convenience factors insofar as that's the test to be undertaken. This is quite plainly a case that it is convenient to deal with cumulatively. The alternative will be a multiplicity of proceedings at the least, and unwieldy proceedings. There are two specific aspects of that that have already been touched on in my earlier submissions, but he suggested that questions of loss would be more complex on the petition if we were in the territory of valuing the claims. Well, on these particular facts in my submission, that can't be right. One has claims, the misappropriation claims that are incredibly closely related to the wider allegations in the petition. So it's plainly convenient to deal with that all at the same time, as opposed to trying to value those claims. Secondly, there was the suggestion that pleading on a derivative claim would somehow have to be more detailed than in a petition. Well, that's just not right as a matter of principle. That's, for example, the case of McKillen. I won't take the court to it, but it's at tab 30, paragraph 12. If anything, the pleading requirements are stricter in a petition, and maybe there are complaints to be made about the level of detail in the petition, but of course those are complaints that should be made in the ordinary way, seeking further particulars or even threatening a strikeout on that basis. But it plainly isn't a convenience factor in relation to the question that the first instance judge was deciding. So in my submission, there is no reason of principle in this case, and certainly no reason of practicality either, not to give full effect to the court's remedial powers under section 996 of the Act. So subject to any...
You managed to come in just in time. Anything else? No. So thank you very much. And we'll start again at 2 o'clock.